So now that we've talked about some of the nuts and bolts, what do we do if we're denied? You're entitled to a written denial citing the specific reasons and factual bases for the denial. So when we talked about all the various exemptions and all the different things that a public body would need to establish in order to properly assert the exemption, you're entitled to specific reasons and factual bases for all of those. And if you don't receive a fulsome and thorough explanation, you'll want to push back to the public body and ask for such an explanation. And you might want to point out any specific things in the exemption that haven't been addressed. Any of those prerequisites, any of the only ifs, but only to the extent requirements. A tool that can be very useful to you in discussing denials and exemption claims with the public body in an attempt to rectify them is to take the public access counselor's online training and use it in the response to the public body if the specific issue has been addressed. I've seen instances in which a public body has claimed an exemption, and when I went to the Illinois Attorney General's office website and to the public access counselor's public quiz that all FOIA officers must take, I found that the public body, through its actions in my request, was actually the incorrect answer to a quiz question. And so if you can respond to the public body with information like that, you may be able to convince them to reconsider their position. The very important thing is stay with it. Sometimes denials come too quickly and maybe weren't completely thought out by the public body. If you stay with it, if you ask for more details, if you provide a response as to why you don't think the exemption claim is warranted, sometimes a public body might reconsider its position and might produce the documents to you. So it's very important to stay with it. But what happens if that doesn't work? Well, you have two main options. You can file a request for review with the public access counselor in the Illinois Attorney General's office, or file a lawsuit. You're no longer required to appeal the denial to the head of the public body. So let's talk about the public access counselor. This is an office within the Illinois Attorney General's office that was created in 2010. And it has the authority to issue either binding or non-binding opinions and orders related to any FOIA request that was denied and for which the requester sought a review by the public access counselor. If you go to the website for the Illinois Attorney General's office, there's detailed explanation of what the process is. But at a high level, you'll submit a written request for review through the website or through the email address or hard copy address that's provided. The public body will need to respond if the PAC's office determines that there's enough of an issue to warrant a response. And then you'll have the opportunity to reply to the public body's response. This is entirely free, and it's also optional. You're not required to go through this process or exhaust this option before filing the suit. And you can elect along the way, before any opinion has been issued, to stop the process, just stop it entirely, or to have it automatically stopped by filing a lawsuit. So what about filing a lawsuit? Well, a court can enter an injunction ordering the public body to produce records to you that were improperly withheld, and the court must award reasonable attorney's fees if you win. And that includes situations in which you may file a lawsuit in response to the lawsuit, but before the court enters any order, the public body, quote unquote, voluntarily producing documents to you. In that situation, you will still have prevailed and still be entitled to an award of reasonable attorney's fees. In other words, a public body cannot deny you records, force you to file a lawsuit, and then once your lawsuit has been filed, simply give you the records and not have to worry about paying the attorney's fees. Now typically, lawsuits can take at least 3 to 6 months to resolve. So that may be something you want to keep in mind in deciding what path to take. Pro bono attorneys are sometimes available, including through the Better Government Association's FOIA clinic, which is held every few months. But if you know any attorneys in any practice area, maybe it's someone who did a will or a real estate closing or represented you in a traffic ticket matter, if you have a FOIA matter that you've been denied and you want to pursue a lawsuit, talk to those attorneys. Let them know that they can recover their fees under the statute and see if they'll take your matter on a contingency basis. And you may be able to find an attorney that way as well. This concludes our presentation on the Illinois Freedom of Information Act. If you have additional questions or issues in the future, keep an eye out for watchdog trainings and FOIA clinics offered by the Better Government Association.